so sorry. Yes, very well.
Sorry, my apologies. There were connection problems, but it's all been sorted.
Good. That's excellent. I will now ask my clerk to call the case on.
In the Court of Appeal Civil Division, before Lord Justice Underhill, Lord Justice Irwin and Lady Justice Nicola Davies, in the matter of Swift v Carpenter, case number B3 2018 2189, on Tuesday the 23rd of June 2020.
Very well. Can I just start with one formal matter and one technical matter? So far as the formal matter is concerned, this hearing is being recorded using the Skype facility, and in the event that anyone wishes to have access subsequently to the recording, a transcript can be obtained from the court in the usual way. That is the only permitted recording. No other recording should be made, either of the audio or of the video, and that includes still photographs and screenshots, and any breach of that will be a contempt of court. The technical matter, which we mentioned yesterday, but there are more people here, is could all those who do not have speaking roles mute themselves at all times, and even those who do have speaking roles, it's helpful if they also mute themselves, except when they are actually speaking. That's perhaps not quite so essential unless we develop feedback problems. Now, we sent the parties an email which they may only have got this morning, making what I think is a point which the parties have already very well appreciated, but I just wanted to get it out in the open. The way things have gone as a result of the extremely impressive cooperation between counsel, experts and solicitors is that although there are still a number of difficult issues for us to resolve, the focus has become narrower than it might have been at looks as though it might have been at one stage. It seems to us, and if we've got this wrong, we better have it out now, that the principal focus of the expert evidence is really going to be confined to two issues. One is as to the workings and the pros and cons of the current Roberts and Johnston solution, or any possible variant of it. And secondly, the valuation of a reversionary interest, if that is the route which the court is persuaded to go down. It seems to us that it is those two areas of the evidence which are most likely to need exploration. And looking at the way in which the time allocated to the various experts has been estimated, it looks as though that's the way the parties see it as well. In broad brush terms, have we got that right?
Well, Lord, as far as we're concerned on behalf of the appellant, we think that's exactly right.
That's a relief. Does Mr. Alden say the same on behalf of the respondent?
My Lord, yes, obviously not to the exclusion of some other issues in the evidence, such as the cash flow analysis, which we say that is one of the exercises done by Miss Angel, which we say most accurately reflects the loss.
Yes, well, I see that you say that, but unless that is going to translate into either an argument for retaining the existing Robertson Johnson approach, or some variant of it, or into an argument for what we understood to be, as it were, both parties' fallback position, that if we were going to depart from Robertson Johnson, but not simply award the whole £900,000 or the capital sum in whatever it happens to be, it's some version of the valuation of the reversion method. And it isn't clear to me, but it will become clear, no doubt, that Miss Angel's evidence feeds into either of those. But if you say it does, I'm sure I will see the light in due course.
My Lord, in our outline, what we say is this: it does on both issues, insofar as it is used to look at whether Robertson Johnson is fair. We say it shows that once the windfall is taken into account, it shows that there is no net loss. And insofar as it informs the exercise as to whether you depart from, this court departs from Robertson Johnson and chooses an alternative method, as you'll have seen from our skeleton argument, we accept it's not necessarily the most pragmatic solution because it would involve actuarial exercises in each case. But we say it is important to inform the valuation of the reversionary interest, because that valuation process, if that is the route this court goes down, must, as accurately as possible, reflect the claimant's loss.
Yes, I see how you put it, and I'm sorry if I hadn't picked it up. I'm sure my lord and my lady had it. Anyway, the object of this just brief run-through is not to exclude any cross-examination that anyone wants to do. It's simply to make sure that we understand what the principal focus is going to be, and that the time spent on the witnesses reflects that. Before we come to the details of timetable, do my lord and my lady want to add anything to what I've said so far about the overall thrust of the case?
No, thank you.
No, simply say, to echo your thanks to the parties, because there's been a lot of work and it has made this difficult process a bit easier already. We can see where we may go.
Yes. Well, I won't echo it myself, but I do want to emphasise that it's been a very impressive exercise and we are appreciative of it. Now, we then just come to practicalities. I have, if I can lay my hands on it, a proposed timetable, and certainly we do not in any way want to unsettle what the parties have agreed, even in the light of the way that matters have moved. Does this timetable reflect all the parties' latest estimate of what time they need for the witness, most up-to-date estimate of the time they need to cross-examine each of the witnesses?
Well, I think it may go a little more quickly, although whether that's ambitious with the medium we're using, I don't know. And I noted that Your Lordship had raised the possibility yesterday of perhaps starting on some discrete area of submissions. I wonder if that's what Your Lordship has in mind, really. In relation
I mean, just to spell it out, if we are going to go up to 315, which is what is estimated at the moment, even on that basis, and assuming that we didn't say, well, we're starting half an hour early, so we'll finish, suppose we were to go on to 4:15, that would be a useful hour's time there. And still more so if the evidence stopped rather earlier in the afternoon. So that was the first thing that I just thought was worth exploring. the second thing that was worth exploring was day 2. Although these are certainly, we're not for a moment suggesting these are the only 2 important witnesses, they may be, in terms of detail and understanding exactly what's been said and how things work, the ones where there's the largest chance of overrunning questions from the court and so forth. So, I simply wanted to indicate that we might be more relaxed about taking more time on those witnesses. And whether that meant actually starting one of them in the gap that there may be this afternoon, or whether it meant taking the whole of the morning tomorrow, or even, I'm not encouraging this, starting at 10 o'clock. We're very open to suggestions on that. But you will have a much better feel, and you will also have some feel, I know this is difficult, about how much time will have to be spent on submissions. To which the conventional answer is it depends how difficult questions the court asks. But I just wanted to float whether there was any adjustments anyone thought should be made to this timetable to make sure we make best use of the time available.
Well, my lord, the only thing that had occurred to us is whether if we have some spare time, if I can put it that way, this afternoon, we couldn't embark on submissions from both sides in relation to the question of whether Robertson-Johnson applies and whether it's an impediment to your lordship and ladyship embarking upon a revision, as it were, of the present position in relation to capital cost of accommodation.
Yes, effectively, stare decisis point.
Yes, exactly. From both sides, that would reorder, as it were, the sequence of submissions. But it does seem to us that that is a discrete issue which isn't going to be informed by the expert evidence. Obviously, I'd be reluctant to start submissions and then have expert evidence effectively interposed, which went to the substance of those submissions.
No, quite. Well, that was certainly very much in the back of my mind, and I think also the other members of the court. Well, shall we see how we go? Mr. Ordeland, do you have any objection to our going down that route if the time becomes available this afternoon?
My lord, no. The only, not in principle, no. The only consideration is whether we would both finish submissions on that topic within the time available, and I'm not sure that we will.
No, I agree to that.
Because
I don't think. So sorry, you go ahead.
The alternative is, of course, to accelerate tomorrow's witnesses into today, and I'm perfectly happy with that alternative, speaking for myself.
Well, can I suggest we deal with it this way? I think the neatest thing will be to accelerate some of tomorrow's witnesses into today, but the witnesses will have been told what to expect and so on. I don't want to create difficulties for them, but if that can be done, that probably is the cleanest way of doing it. If it can't be done, I don't see any problem in adopting Mr. Sweeting's solution. I take your point that it may be ambitious. Let us say we're talking about an hour max to get submissions from both sides on this quite knotty issue done and dusted. But I don't think it would matter too much if, on a pessimistic view, Mr. Sweeting had finished his and you hadn't started yours, or even if you had to break yours off, we're perfectly capable of storing that and coming back to it after the evidence tomorrow. Well, can I suggest that the two of you, or everyone else involved, have a discussion of that over lunch? Or just possibly, if we run out of things to say before 10:30, if you would like 10 minutes to discuss a way forward, and before we start with Mr. Davies' evidence, we'd be happy with that as well. Are there any matters that any counsel, or either my lord or my lady, would like to discuss apart from that before we get into evidence?
Well, can I just mention that Mr. Watson is, of course, Mr. Allen's witness, and it may be there is something he would want to say about Mr. Watson's availability. I don't know. I think his concern in the original sequence of expert evidence was that we should not divorce Mr. Watson's evidence from Mr. Robinson's, and they should be taken back to back by the court.
Yes, but that doesn't necessarily mean it's on the same day.
No, quite.
Well, look, I wonder whether the right way forward isn't actually this, that Mr. Davies wasn't expecting to start till 10:30, that you don't just take 10 minutes between yourselves to discuss a sensible timetable or any revision to the timetable. We will be entirely comfortable with what works for you. We just don't want to waste what may be a significant chunk of time this afternoon. My lord and my lady will formally leave the meeting, or at any rate switch off our... I think what we'll actually just do is switch off our mics and video and switch them on again at 10:30. That has the disadvantage that anything you say, if you're not muted, will be heard. So if you're going to have any conversations using this, which you're welcome to do, no, sorry, I'm expressing myself badly. Don't have any conversations using this, because we will be able to hear them and mute yourselves. Good. We'll see you all at 10:30.
Sorry. Yes, do it. So it's just one's always leery that it could be. Right. I think the safest thing I can do is actually leave.
That's fine.
Okay, Scott?
That's fine.
They've been working all the time, I know, because they've been in
Time.
What are they doing?
They've got a blast. One of those water blasts that escapes.
All right. It's nice to see you. I'm very glad you're in charge.
Thank you very much.
I'm going to change my files.
10:30 by my computer. I don't know whether you have anything you want to report at this stage. No obligation to. We can look at it again at lunchtime. But if you'd like to, before we speak to Mr. Dakin, please do.
Well, my lord, I've heard from Mr. Allen, whose witness Mr. Watson is, and his preference would be to have Mr. Watson and Mr. Robinson back to back tomorrow, but Mr. Watson could start this afternoon if that's more convenient for the court.
Well, I don't want to get into a sort of battle of courtesy about this. I think if it is Mr. Allen's definite preference on behalf of Mr. Watson to have both witnesses tomorrow, we'd be content with that. It's less elegant than hearing all the witnesses straight through, and but it's not the end of the world if we can make use of the time in between all the submissions. So although I haven't had the opportunity to discuss with my lord and my lady, they will express vigorous dissent if they take a different view. They aren't. Well, in that case, I think let's stick to the plan as long as we do use that time. Very well. Then it's for you to call Mr. Dakin, Mr. Sweeting.
Yes, my lord, that's right, and the court's directions really dispense with any openings at this stage, and we're going to move straight to the expert evidence, and that begins with the evidence of Mr. Dakin, who I see is online, and I think should therefore turn on his video if he can do that.
I have done so.
Excellent. At the moment I can't see you, but I will sacrifice I don't think I can. I'm so sorry. I just got to manage my screen. I will.
I think the participant list, my lord, does say that my video is on.
Yes, I'm sure. It's just that we have you now, Mr. Dakin. Excellent. Very well. Now, the parties arranged a sensible and pragmatic way for you to take the oath or affirm as you choose, which I hope has been explained to you. But perhaps you could do that first. If you have any questions, please do raise them. But as I say, I hope it's been talked through with you.
My lord, I haven't been given any particular instruction, but I can give the usual affirmation.
Yes, if you would do so.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Very well, thank you, Mr. Dakin. Now, Mr. Sweeting, I haven't actually refreshed my memory about the directions, but either you have nothing in chief except for the formal stuff, or at any rate only severely restricted. But I'm sure you have an understanding with Mr. Ordland about that.
Well, that's right. I think the restriction was essentially no more than 10 minutes, so I'm just going to identify the relevant material with Mr. Dakin, some of which has come a little later in the day. So, Mr. Dakin, could you just give us your full name, please, and your primary professional qualification?
My name is Christopher David Dakin, and my professional qualification is Fellow of the Institute of Actuaries.
Right, and I won't obviously ask you to repeat any part of your curriculum vitae which is set out in your report, but I know you're a member of the Ogden Working Party from the early 1990s to September of 2007.
That's correct. Because I was in fact the government actuary during that period, and I signed off the explanatory notes of several editions of the Ogden tables, and I'm now back as a member of the Ogden Working Party as an independent actuarial expert.
Thank you. And your report prepared for the purpose of these proceedings is in the expert bundle at tab 14 at beginning of page 86. I think you may have.
That's correct.
And in addition to that report, you produced a supplemental report, which is at tab 23. Was that designed to express a view about the potential effects of the present pandemic on the calculations and opinions that you had set out and expressed in your report?
Yes, I was just concerned that there may be some issues around the current situation which the court would want to know my updated opinion if anything had changed as a result of the circumstances in which we now find ourselves economically and socially.
Yes. Well, I think in a nutshell, your view was that the present emergency introduced yet further uncertainty into forecasting.
Yes, very much so, and that was particularly in relation to my views of the other witnesses' reports. My own report didn't contain much which was specifically dependent on the economic circumstances, and so I didn't need to change any of my figures or arguments.
Now, in addition to those two reports, Mr. Dakin, at tab 11 in the expert bundle, the second of the bundles, I think, there are replies to the respondents' questions, you being asked a series of questions on behalf of the respondent about your first report.
Yes, that's correct.
So I think those are the totality of the views that you've expressed in connection with this litigation. But recently, in fact, I think just prior to the weekend or over the weekend, you've produced a table of further calculations. I wonder if I could ask if the court has that short one-page tabular document.
Yes.
I certainly know I have received it. How quickly it will take me to lay my hands on it is another matter. Just give me a moment. Sorry to keep everyone waiting.
Could I just check, is this the single sheet that is headed tables corresponding to paragraphs 16 and 17 on the Watson report?
Well, that's the one, and I apologise, I should perhaps have teed this up in advance in the absence of being able to hand things up to the court.
That's all right. It's got Mr. Watson's name on, but it's actually Mr. Dakin's.
It is, that's right.
Analysis.
I think I have it at last. Is it... It's probably what my lord just asked, but table corresponding to paragraph 16 and 17, is that the one?
Well, that's the one, yes.
Yes, I'm sorry about the delay, yeah.
Not at all. And we can see that on the left-hand side, the left-hand column, you've identified this case, Swift and Carpenter, and then the various paradigms which had been selected by the parties. Can you just tell us in very short terms, Mr. Dakin, what the table shows and why you produced it?
Yes, the table shows the figures that Mr. Watson produces in his report for the value of a reversionary interest and the value of a corresponding life interest, which is the obverse of the reversionary interest. He expresses an opinion that the rate of yield should be 6.6%, and so he gets a number of 49,000 for the rounded value of the reversionary interest, which you can find in the 6.6% column and the sixth line, or rather the fifth line of actual figures, I think, in the table. I produced the table both in order to set it in the context of looking at different rates of interest and how sensitive the results were to the rate of interest, and so I've given the full range, if you like, without expressing an opinion as to the appropriateness, all the way from 1% up to 7%, and I done the same for the three paradigm cases, so that the court can see how it works for them as well. These are calculated purely on the basis of that rate of discount being used as a compound interest rate. From reading Mr. Watson's report, you'll understand that the way in which he does it, he assumes an underlying mortality rate, and then he derives a discount rate from that, which is essentially then used as a compound interest rate. So the reversionary interest assumes fixed life expectancy, 45.4 years, and compound interest, so it's like a table 28 approach from the Ogden tables, but you get the idea of the range of outcomes and how sensitive it is to the rate of interest assumed.
Yes, table 28 being a multiplier for a term certain.
Yes, what actuaries would call compound interest rather than allowing for mortality.
Thank you very much indeed. That's all I have to ask in examination in chief.
Mr. Sweeting, before cross-examination, could we just decide where we're going to put this table? Because it hasn't got the page number, and tomorrow morning we'll all be fiddling around trying to find it.
Would it be sensible to put it with Mr. Dakin's report, either at the start or the end? I personally tend to prefer putting things at the start if they've been introduced, but
Beginning of tab 4, the main report.
Yes, that's right.
Thank you.
Obliged, thank you.
Yes, thank you very much. Mr. Orland.
My Lord, I meant to mention at 10 o'clock that Mr. Viney and myself are both asking questions of witnesses, and Mr. Viney is asking questions of Mr. Dakin and also Mr. Cropper, and I will be examining the other two witnesses.
Very well.
Waiting.
Sorry, my lord, I was just waiting so that we didn't introduce feedback into the system. I hope that the court can hear me and Mr. Dakin can hear me.
Yes.
Thank you very much, Mr. Dakin. Can I just, before we start, just check if we've got the following material relatively reasonably to hand, because they're the material that we'll be looking at. The two expert bundles, so bundles 1 and 2.
Yes.
And the core bundle we'll look at briefly, so if you can have that somewhere to hand.
Yes.
And in due course we'll look at the calculations that have just been introduced as well, so if they're to hand, if you haven't put them in the beginning of tab 4. Can I start by asking you to turn to page 90 of expert bundle 1?
Yes, I have turned to that.
You have page 90, at the bottom of page 90, paragraph 2.5, which goes over to page 91. You sum up what really is the issue here in this case, that when damages are used to purchase, or capital is used to purchase a property, it's exchanged for a valuable asset. asset can then be passed to the estate. It's correct, isn't it? That asset can be used for several different things. It can be used as security for loans, equity release can take part, and if necessary, the claimant can also sell on the asset and use the money for other purposes if she wishes to do so.
Yes, that's correct. It becomes an asset of the claimant.
Yes. And the difficulty we have to deal with, the court is going to depart from the standard Watson Johnson principles, how else one allocates the benefit of that asset against the cost of that asset. Do you agree with that?
Well, I think this is the nub of the issue, because if you simply compensate for the capital value, then the claimant has acquired a capital asset, and in principle that should in some way be offset as a reversionary interest for the defendant.
If we can then turn forward to section 3 of your report, which is page 93 of that first bundle.
Yes.
Which page did you say, Mr. Viney?
Page 93, my lord.
Yes, thank you.
At section 3, you set out principles, and then picked up by Mr. Cropper in his report. You set out 7 principles which you say ought to be considered when attempting to deal with this issue. That's right, isn't it?
These are principles which I, as an actuary, feel should be taken into account, having regard to the legal framework in which I am providing advice.
Okay, and can I ask you to leave that page open, but also, if you can, I appreciate that desks may not be quite as large as they are in court. Turn to expert bundle 2 and page 498. It's tab 11, page 498.
So sorry, Mr. Viney, I'm being very slow. Which bundle?
Expert bundle 2, my lord, tab 11, page 498.
Yes, thank you, I have it.
Yes, I have that.
And tab 11 are your responses to questions that you were asked, and at page 498 is your response to question 4. Do you have that?
Yes.
For that page.
I have that there.
And you were essentially asked about where these principles came from. And you say they're based on my understanding of the objectives, the exercise of compensating claimants and implementing that 100% principle set out in previous court judgments. Now, the first question are these principles that you formulated yourself?
Yes, they are.
And you say that they implement principles set out in previous court judgments. Which court judgments did you look at when formulating these principles?
Well, I am not a legal expert, so that's not really my area of expertise, but in all the work that I have done for the courts in this sort of field, I have been constantly reminded of different judgments which apply the principle of 100% compensation, which I understand goes back to a court case in the 19th century. But I think it would be for the legal experts to comment on the specific authorities on which this is based. But everything that I have done in this context over recent years, which is now over quite a number of years, has always worked on the basis that the principle that we're attempting to work to is that there should be full compensation of the claimant by the tortfeasor.
When you set out these principles, did you take into account, or do you consider it relevant that when awarding damages, a court should consider the sum which is likely to be adequate for the period of loss, but will not leave the claimant better off at the end of that period?
Well, I think one of the principles I mention is it's the seventh principle, 3.7, which is that a principle that the claimant should not enjoy an unexpected windfall as a result of the claim. I mean, I think in the normal context of reimbursing claimants for ongoing costs, there is a clear possibility of either under or overcompensation, because they've usually are given on the basis of an expectation of how long the person will live, which is a pure mathematical concept. And of course, the person could live longer and could live shorter. And sometimes they could be overcompensated and sometimes undercompensated. But it's part of the process, and it's part of the basis on which the Lord Chancellor set the discount rate, to weight that more heavily in the favour of the claimant, not to have a 50-50 outcome, but to have an outcome which reflects the fact that the object to the exercise is to ensure that the claimant is properly compensated.
That was something that the Lord Chancellor did when setting the discount rate in 2019, and is something that's within the power of the Lord Chancellor by way of statute. In terms of the court's approach to these matters, hasn't it always been your understanding that the court would seek to balance the interest without the balance falling heavily on one side or the other of the two parties?
Well, that's certainly not my experience, and I look to cases like Wells in the House of Lords, or the Helmut versus Simon judgment in the Privy Council, both in which I was involved as an expert witness. And the clear intention of the court was to balance the award in the favour of the claimant. So the House of Lords, for example, adopted a risk-free approach, which was clearly absolutely skewed towards the interests of compensating the claimant properly.
But they did not adapt that risk-free approach to assure that there was more than effectively a 50-50 balance between over and under compensation, did they?
No, I don't think that's true at all. The risk-free approach gives almost 100%. I mean, barring the question of expectation of life, which is still an open question by using multipliers. But the idea of using a discount rate based on index-linked gilts was to skew it very heavily in favour of the claimant. The Ministry of Justice has rowed back from that in recent years, and of course we have the Civil Liability Act 2018, where Parliament overrode that in favour of only taking a low-risk approach to investments rather than a risk-free approach, and that is clearly a shift in the direction of the defendant, but it was still the case in setting the discount rate in July 2019 that the Lord Chancellor added to the discount, or rather I should say added an element into the discount rate calculation which skewed it more towards being in favour of the claimant, and so avoided any sense that it was 50-50. It had to be sufficient in the large proportion of cases to meet the claimant's needs.
And you're saying that's a legal principle you assume the court will adopt?
I would expect so. Of course, that's for the court to decide, but that was my interpretation in giving my expert witness.
So, and in terms of giving your evidence has therefore taken that as the lead. You're looking at a system that will skew in favour of ensuring that the claimant has at least sufficient, if not more than sufficient, funds.
Yes, in my view, it's rarely more than sufficient, but you have to skew it in that direction, otherwise you end up with it being unfair to the claimant and not being adequately compensated.
So when we look at the figures you adopt in your report, you're taking that very much in mind in terms of the figures you consider reasonable for the assessment in this case?
Yes.
Thank you. If I can then just start, I'm not going to deal with all of your principles because of the limited time that we have. But firstly, if we just start and look back at Expert Bundle 1, hopefully you've still got the page open, page 93, tab 4.
Yes.
The first principle, as you say, is a fundamental principle, is in such cases is paragraph 3.1. That the cost should be appropriately compensated in order to achieve full compensation. Not to do so will lead to explicit undercompensation.
Yes.
Now, that begs the question, doesn't it, as to what is appropriately compensated?
Well, that, if I might say so, is really a matter for the courts to decide, or for Parliament, the experts operate within a framework which is set by the courts, and we follow the way in which this has been approached by courts in previous cases. Of course, that's maybe our interpretation, and it's up to the courts to decide whether that's appropriate or not.
One way of assessing whether the compensation is sufficient is to carry out a cash flow analysis, as Miss Angel does.
I'm not sure how that proves anything. I mean, that's a purely mathematical exercise based on a set of multiple assumptions, most of which may turn out not to be the case. So it's just a hypothetical calculation.
It's a calculation based upon the court's assessments of the claimant's needs, isn't it? Because it adopts the damages awards made by the court.
Yes, but if I might be so bold as to say, the court agrees a figure for damages. It doesn't agree every individual number that lies underneath that, and in practice all of those figures will differ from the figures that go into assessing the amount of compensation. So I think it's really stretching a point to say that you can do a full cash flow analysis on that basis, which also depends on how long people live and how all sorts of factors turn out to be the case.
Yes, and the court makes assumptions about life expectancy, or reaches conclusions about life expectancy. It reaches conclusions about the individual heads of damage. And we can see that in the judgment in this case, can't we? And all those factors go in to make up the final award of damages.
Indeed, they make up the final award.
And if you adopt those findings of the court, you can carry out the analysis that Ms Angel has carried out to assess if the court's conclusions as to what is required are accurate, and I accept, and I think probably the court will probably accept, it is unlikely that its assessment is ever going to be absolutely accurate because of the various uncertainties that do arise. But if the court's assessment is accurate, then you can adopt how much cash is needed to meet those needs.
Yes, I accept that, but it's a hypothetical calculation based on a very large number of assumptions.
Yes, well, you say hypothetical, it's based upon the court's conclusions as to what is required. So
that doesn't stop it from being hypothetical.
So your view is that the court's conclusions themselves are hypothetical, so you use it in that term?
No, it's the modelling which is hypothetical, not the court's conclusions.
Can we move on then to your third principle, which you say is a fundamental principle? And this is at paragraph 3.3 on page 93. And you say that it is fundamental, that the claimant should not be required to use compensation received for other heads of damage in order to finance necessary improvements to the property. Can I just clarify, by that you mean effectively the capital input into purchasing a larger property, do you?
Well, I think my point is that each head of damage is calculated separately, and it muddies the issue if you start saying that you can use one head of damage to meet the costs under another head of damage. A particular head of damage that we're dealing with in this case is the accommodation head of damage in relation to the capital cost of improving a property, and to my mind that needs to be looked at as a separate head of damage, and of course the court could decide differently, but my view was that all previous damage assessments have worked on the basis that each of the heads of damages is calculated in a separate way, and so this one should be as well.
Sorry, can I just be clear? This is a reference to the extra capital cost of accommodation because you referred to it as necessary improvements to the property. I just want to be clear that you are talking there about the additional capital cost of the accommodation.
Well, there may be two elements. There may be a capital cost of accommodation. There may be a cost of improvements. The cost of improvements, I think, probably doesn't create the same controversy as the capital cost. So maybe the thing which is most important in our focus in this case is the capital cost, but the principle applies to all costs.
Yeah, but I think Mr. Devine's point was that, with retrospect, you're not really focusing, when referring to improvements, you're not really focusing on where the real issue lies, and with hindsight that might be slightly better expressed so as to refer to the additional capital costs. Would you accept that?
Thank you, my lord. I think I was referring to improvements as being money that you pour into the house in order to get a better house. Now, that might be improving a house that you already have, or it might be buying a better house, but it's still an improvement.
Sorry, Mr. Dale, I wasn't trying to be critical in any way. I was just trying to make sure I understood that you are taking into account, you're saying that other heads of loss shouldn't be used to finance the capital costs of purchase of the property.
That was my view.
And that's, you say, a fundamental principle.
Well, it was one of the principles which I set out under which I would give my evidence.
So is there any, as far as you're aware, are you aware of any legal basis for concluding that was a fundamental principle?
I'm not a lawyer, so I wouldn't want to comment on the legal basis, but it's my experience of the process of compensating is that each head of damage is looked at separately, and there isn't any environment between the heads of damages normally applied, other than in a compromising settlement where there is generally a whole sum agreed, but in the court's consideration, including the case we're dealing with here in front of Her Honour Mrs Justice Lambert, she looked at each of the heads of damage separately, and there wasn't any attempt to sort of merge them together and say, oh, well, there's a possibility of overcompensating in this head of damage, so we'll give a bit less on another.
I wonder if I could just break in to ask a question. Mr. Dakin, you, in the principle that you're being taken to, you seem to me to wrap up two things. One, the calculation of the amount of compensation that is needed, and secondly, how it is delivered. In answering the questions from Mr. Pliny, you have, I think, stressed how the losses or need for compensation is calculated, but I think he's pressing on you that the implication that in this particular instance it's defrayed without a separate capital award. I just wonder if there's a confusion between question and answer.
Well, my lord, there could be, but I think I was certainly looking at it in the sense of how the compensation is assessed. How the courts award that compensation is, of course, a matter for the courts rather than for the experts. But I wanted to make sure that I drew a distinction in setting out my stall, if you like, the sort of principles on which I would be looking at this. That I thought that this particular head of damage and the capital cost element of it, which we're talking about, needs to be looked at separately and shouldn't be conflated with other heads of damage and other elements of compensation.
Thank you.
So, Mr. Dakin, slightly earlier when we were talking about the first principle, you were making the point the court awards a single award of damages, and you were criticising the cash flow analysis because it looked at the separate elements of damages and assessed the need for that. So here, you say that actually you've got to look at the separate elements of damage and just simply look at the capital costs of the property in isolation, and you say that's a fundamental principle.
Well, that seems to be something that ought to inform my advice, but this is something that I look at on its own and without begging or borrowing from other heads of damage.
Is that an actuarial principle in any way?
Not necessarily. I mean, an actuary will respond to whatever the principles are of the context in which they are advising. But in this particular case, the nature of the compensation we're talking about in respect of capital cost of accommodation is somewhat different from the other elements, and so it does make sense to regard it as an entirely separate component.
Because you didn't, well, the cash flow approach was being trailed prior to you being instructed, hadn't it? Because it was one of the issues that was raised the first time this appeal went through. Were you aware that it was being said that by the respondent in this appeal that in effect very little or no extra capital was needed by the claimant to fund her damages?
I was aware of that case having been advanced, but until I saw Mrs Angel's report, I wasn't aware how that was being interpreted in terms of an overall cash flow analysis.
Yeah. You didn't attempt to do your own analysis in any way, did you?
No, because I thought that would be a fruitless exercise, and it was contrary to the principles that I was setting out anyway.
So you set out principles which made it a fruitless exercise. If the cash flow analysis determines what is likely to be needed by the claimant in the future to meet her needs, why would you say that's fruitless?
Well, I think what's fruitless about it is that you're adopting a whole lot of assumptions about how the world will develop over the next 100 years, which are purely hypothetical. And to my mind, it still begs the question, well, why would you want to do that, since we're trying to determine the value of the capital accommodation to the claimant? All of this other information is of subsidiary interest. Now, of course, the court could decide that the way it wants to look at it is to look at the whole picture and to carry out such an analysis. I mean, I think that would point in the direction in every such case having to have an actuarial report of 50 pages or so. I think Mrs Angel's is quite a lot longer than that, but with a full analysis which involves a massive modelling exercise, seems to me disproportionate. I'm not sure what the court would want to go that way, but that's a matter for the court rather than for me. But it wasn't part of what I thought should be the considerations in giving my opinion to the court.
One of the assumptions that you criticise, or the assumptions that you criticise, relate to assumptions as to inflation, as to house price growth into the future, don't they?
Indeed, I thought that was the most bizarre assumption I've seen in a while.
The House of Lords in Thomas made an assumption as to house price growth into the future, didn't they? Because they assumed that house price growth would match RPI.
Yes, but with respect, that's an entirely different issue, because they were looking at house price growth as set against the yield. So they were looking at real returns. What is objectionable in Mrs Angel's report, which derives, I understand, from her instructions, is an unguarded assumption of 3.2% per annum growth in house prices on its own, which is meaningless. I mean, you can only look at future price changes in the context of yields and real returns. To make an assumption about what prices are going to do over 100 years in the future is absolutely a fool's game.
Do you at any point make any assumptions in your report about what house prices are going to do over the long term?
No, because I assume that the value of the reversion would be determined by market values, and the market value is assessed by people who are able to look at their expectations expectations of what might happen to house prices and to set that against what rate of return they would want. And that's why they come to a number like the 6.6%, which is referenced in Brian Watson's report as a reasonable yield assumption, being a real yield assumption, incorporating the inflationary developments, but no explicit assumption is made there about price increases. And I think that's what one should avoid. It's interesting that the 3.2% has come down in the recent calculations or the supplementary reports from Mrs Angel and Mr Wilson. I think they've got even more precise number now. I seem to recall 2.89% or something for the next 100 years. That's a really interesting, accurate figure to be able to predict for 100 years. And my view is that it's completely spurious because this is possibly something you want to talk to Dr Llewellyn about, but in my view the future of house prices is complete unknown. I mean, what's going to happen to the world over the next 100 years? We've got climate change issues, we've got people moving out of town, learning to work remotely. The housing supply situation will change. There is absolutely no basis on which one can make an assumption of 3.2 or any other number as the annual increase in prices for the next 100 years.
So I think your answer to my question is that you don't make any assumptions about house price growth in your report.
That's right.
Okay, do you assume that there will be no house price growth?
Well, I think in some parts of my report I do, because I started off from the assumption that we were looking at a sort of cost of borrowing approach, which was really that the 900,000 would be advanced to the client and then would be repaid at the end. So the interest of the lender was in the repayment. And then I talked about the possibility of including the increase or decrease in value of the house in that, and I said the only way we can do that is by taking the market value as it would be assessed by a reversionary interest market.
Okay, so at some point you assume that over the next 45 years, I know you say up to 100 years, I'm not sure that anyone is predicting up to 100 years, but over the next 45 years there will be no house price growth at all. It is the assumption that underpins some of the calculations.
Well, I don't think that was an assumption underlying my calculation. It was just an assumption underlying what we were trying to cover in the reimbursement. I was wanting to ensure that the 900,000 was reimbursed in some way at the end, either through having to be repaid or expressed in relation to a reversionary interest. And the question of whether house prices would have gone up or down over that period, it was a separate issue.
So you use an assumption effectively of no house price growth over 45 years.
That's the case in one part of my report, I think.
Is that a reasonable assumption?
Oh, I wasn't saying that the house price wouldn't have gone up. I'm saying that the value of what we were trying to reimburse to the defendant wouldn't have gone up.
Okay, so would it be, if someone made an assumption that there'd be no house price growth over 45 years, would you regard that as a reasonable assumption?
Well, it's a possible assumption. I think if an actuary was doing a report on this using a stochastic approach with a variety of different possible, that would be within the scope, because it's quite possible I would advance that house prices might actually fall over the next 50 years.
Mr. Taylor, would you regard it as a reasonable assumption?
Yes.
So the reasonable assumption of no house price growth over 45 years.
One of a million possible reasonable assumptions.
Okay, can we turn to page 117 of Expert Bundle 1?
So 115?
17, tab 4, page 117.
You're referring to the appendix.
I'll tell you what I'm referring to. You've got page 117, it's appendix D, and it's paragraph 4 I'd like you to look at.
Yes.
Paragraph 4, you make an assumption, don't you, about the returns on residential housing?
About the real returns, yes.
Yes. You assume the real return is minus 0.5%, and you base that, if you read the second line, the capital values rising in line with inflation.
Yes.
So you make an assumption for the purpose of this element of your report that capital values rise in line with inflation. Do you regard that as a reasonable assumption?
I think it was an assumption which was intended to be aligned with the way in which the government actuary had carried out his calculations, in which he assumed a element of the portfolio to be in property, but of course in commercial property, which largely delivers its return via the rental income. So the capital may fall, but the rental income goes up. So this is just an assumption. I have to say that the whole of this Appendix D was purely intended as an illustration. It wasn't intended as a rigorous calculation. I am not in a position to be able to replicate the government actuary's stochastic analysis exactly. So I was just giving a rough calculation to show that the insistence of putting 25% of the portfolio into a residential property with no income attached would diminish the return on the portfolio quite markedly and would therefore impact on the way in which the discount rate was calculated. So the purpose of this is not to arrive at a particular number, but just to show that the discount rate would be significantly affected if you made this assumption. The Lord Chancellor had set the discount rate on the assumption that only 75% of the portfolio was invested. He would have come up with a different number, and that would have reflected back on the settlement made by the Court of First Instance in this case. So it throws into question the whole idea of using the house as a valuable asset for the purposes of the compensation calculation process.
Mr. Dakin, my question was, when you made this assumption for this part of the report, did you consider that the assumption that capital values will rise in line with inflation was a reasonable assumption?
I think it was a reasonable assumption for the purpose that I was using it for in this context.
And you, this part of your report, adjust that assumption down, and you say you do that because the limited resources of the claimant spend enough on upkeep to avoid the value of the property slipping behind the market.
That's one of the factors. It just seems a reasonable assumption for me to make this. As I say, the whole purpose of this appendix was a heuristic calculation to show what the impact of this might be. I wasn't attempting to give advice or recommendations in this respect at all.
Mr. Dakin, we've got a limited time. If you can listen to the question and answer the question. I think that's slightly unfair, Mr. Viney, but anyway. Sorry, my lord. I
believe I have answered your question quite adequately, and I'm not going to say any more on the subject.
You say that the assumption that the property wouldn't be kept up to the maintenance properly was one of the factors for reducing it. You don't set out at that paragraph any other factor, do you?
I don't, but I've already mentioned several other factors in this discussion, including the fact that London property prices might fall by 50% over the next 50 years as a result of people moving out of town.
Do you think that's a reasonable assumption, Mr.
I think that would be a very reasonable assumption in the current circumstances, but I'm not using it as an assumption to arrive at a recommendation here, as I've already said 3 times. I'm using this just as an example to show that you cannot constrain the valuation of the portfolio without impacting the discount rate. And so you have to go back to square one and then reassess the discount rate in the light of what you've decided to do about the portfolio.
Now, Mr. Dakin, when you prepared this report, were you aware that claimant had received a substantial damages award to pay for the maintenance of the additional elements of the property that she needed.
Yes.
And why then did you adjust for an inability to maintain if the claimant had been provided with damages to maintain?
Well, because the reality of the situation with anybody who owns an owner-occupied house is that there are sometimes constraints on what you decide to spend your money on, and you don't necessarily upkeep the property to the extent that might be ideal in order to maintain its value. That's not first and forefront in your considerations, and particularly as the claimant gets much older, there would, I think, almost inevitably be the possibility that the property would be less well upkept, and indeed that money would be needed for other purposes out of the settlement which was made, and so keeping the value of the house up would not be her first priority.
So, despite the fact that the court has assessed what the maintenance needs are and awarded damages in that respect, you make the assumption that the property isn't going to be maintained in these calculations.
Well, I think that's a prudent assumption to make when you're setting the discount rate, which is what I'm doing here.
Can I ask you to turn to the second expert bundle at page 498?
I think I'm already there.
And you've got that first bundle open. Can we just, if you've got the first bundle open, can you just turn from page 117 to 118?
Yeah.
If we look at paragraph 5 of Appendix D, which is the top of page 118. At that point, you try to do a comparison between the award that was made of £3.8 million for future loss to the award that you say should be made if you adjust the discount rate, and you apply and multiply to the award that was made of 48.34.
Yes.
Now, that multiplier was incorrect, wasn't it? The multiplier that was applied to the award that was made of 3.8 million was 55.02.
Well, I think we're talking about different things here, because I'm looking at this in the context of how the Lord Chancellor set the discount rate in July 2019, which involved this notional portfolio, which I'm trying to adjust and see what the impact would be. I think you're referring to the case of first instance, which was based on a discount rate of minus 0.75%, in an entirely different paradigm for setting the discount rate, where the discount rate was ostensibly, at any rate, set as the risk-free real rate of return.
But you used the figure of £3.8 million, didn't you, here? Because that was the award for future losses made in the original case.
Well, I was just ratioing the amount of award to what you would get using a discount rate which was different from the one that was used previously, and that was a rough way of doing it. This is an order of magnitude calculation. If necessary, one could do a more accurate calculation. I think all I was showing was that it was not difficult to come up with an increase in the value of the award, which could be of the order of £1 million, which would really make a big difference, and that is a pure consequence of making the assumption that you force the claimant to invest 25% of their portfolio in a non-interest bearing asset.
That's a consequence of assuming that there's an award of damages of £3.8 million calculated at minus 0.25% discount rate. And
It doesn't matter what rate of discount you calculate it at, I'm just ratioing it to allow for the change in discount rate, not to allow for the absolute level of discount rate.
it does matter what level of discount rate you calculated at, because if you calculated at a discount rate of minus 0.75%, one part of the ratio is substantially increased. The multiplier would be not 48.34, would be 55.02.
Yeah, but both sides of the equation would change, and so the ratio wouldn't be different.
So, are you saying this wasn't supposed to reflect Mrs Swift's case at all? Or do you accept that you used the wrong discount rate?
No, I didn't use the wrong discount rate. I object to that reference. I'm saying that this is a calculation which is intended to show that it doesn't make any sense to require the claimant to invest 25% of their award in a non-interest bearing asset unless you take that into account in the setting of the discount rate. And of course the courts could choose to do that. They could say, well, that's a requirement that you insist on them investing in their property, but then the whole process for setting the discount rate would need to be revisited, and you'd end up with bigger compensation amounts from lower discount rates. So I think it would be a circular process, and it just shows the futility of suggesting that you enforce a particular investment on the client, the claimant, in this situation or any other situation.
Can I ask you just briefly to turn to the second expert bundle, page 500?
Yes.
Can I just ask you to look at 12A, your answer to 12A?
Yes.
You were asked to...
sorry, I'm just behind you for a moment.
Sorry, my lord.
498, did you say?
Page 500.
Expert 500. Yes, thank you.
Happy that, my lord.
So sorry, Mr. Viney. Do you about your question?
Sorry. Mr. Dakin, you were asked to make a change to your assumptions to assume that the residential property was at 0% in relation to RPI rather than the minus 0.5 that you'd used in your calculation. You said that would change the reduction in yield to 0.45% instead of 0.85%. I don't think that calculation is right, in fact, because if you increase the yield of a quarter of your portfolio by 0.5%, then the overall change isn't 0.4%, it's 0.125%.
Well, I did the calculation at the time. I don't have it in front of me. It wasn't a calculation that I thought a particularly sensible calculation, but one I was asked to do in the Part 35 questions, and I came up with what I believe to be the correct answer.
Can I move on just to ask you briefly about Ms Angel's cash flow analysis? You've seen that, haven't you?
I have, and spent some time discussing it with her.
And if there were any calculation errors in it, you would have highlighted those.
Well, I wasn't trying to check her calculations. I had some difficulty in reproducing some of the numbers, and I pointed out some things to her which I thought I had difficulty with. She came up with some explanations. I'm sure that she's quite capable of doing her calculations correctly.
So as far as you're concerned, you're not aware of any inaccuracies in those calculations?
Not aware of anything being incorrectly calculated.
Can I then move on? And my lord, I'm aware that it's now 11:30.
I'm sure you'll have a small amount of indulgence, but
there's one area I do just want to finish with before I finish, if I may. If we look at
the reversionary interest approach, which you deal with in your original report at page 101. Sorry, it starts at page 100.
Yeah.
And it carries on to page 101, section 7. Now, you first of all start by saying in paragraph 7.1 that your understanding is that the only vehicle for sales of reversionary interest is H.E. Foster and Cranfield. And we've seen evidence from them, and they do appear to be the only people who sell these interests, and they sell a very limited number of these interests, don't they?
It's not a big market. I mean, part of the market where they also sell other types of interests on life. I've been aware of this market for a very long time because my father used to monitor the yields on the Foster and Cranfield market in the 1960s. So when I was a young actuary, I was very conscious of the Foster and Cranfield market in reversions and similar interests.
If we turn to the joint statement and expert bundle 2, just leave the expert bundle 1 open because we'll come back to that section. But if we turn to expert bundle 2, to your joint statement, and page 521 of tab 14.
Yes.
You say towards the bottom of the answer at A that you would consider the market value of such interests as your guide. That's right, isn't it?
Yes, I think throughout I've taken that as my position, both in my original report and in my joint report with Mrs Angel. It seems to me the only realistic way of valuing the reversionary interests, which balances the interests of the claimant and the defendant, is by adopting market value or a synthetic market value based on a similar yield to what the market would utilise.
You turn back in expert bundle 2 to page 517. Paragraph 3.2E at the bottom of that page. These are matters which were agreed between you and Mrs Angel in the joint report.
Yes.
You say in 3.2E that it's a perhaps don't take into account defence reversionary interest will depend on whether super assumptions can be determined to value the way which bears both claimant and defendant, which could be by way of the court settling the assumptions by simulating a market value to the extent that a robust set of underlying assumptions can be inferred from the market in such interests. Now, from Mr Watson's evidence, do you regard that as a very limited sales, and the basis is opinion only on we have limited details of 3 sales? Do you regard that as something from which a robust set of underlying assumptions can be drawn?
Yes.
In terms of those assumptions, the people that Mr Watson is purchasing, Mr Watson's customer, the people who purchase reversionary interest in the market, Mr Watson gives evidence about, have to make assumptions as to various aspects of the person who is selling them, including life expectancy, finances, the terms upon which any trust are settled, they're all factors which have to be taken into account in considering what the yield are, aren't they?
I would imagine so. I'm not an expert in that market. I suggest you put those questions to Mr. Watson.
Can I just suggest to you that, because you describe this market, you said this evidence is robust. If we don't know what medical conditions a person in that market may or may not have, any person purchasing an interest in that market is going to naturally be concerned by the prospect of the market hazard of people only selling interest where they are in very robust health. If they're about to die tomorrow, they don't tend to sell the reversion, or the life of tenant is about to die tomorrow, the reversionary interest doesn't tend to get sold.
Well, I'm not sure you can make that assumption. I suggest you ask Mr. Watson. But anyway, I thought that the yields that are available on a number of cases from that market provide a robust basis. In other areas, having 2 or 3 quotes, for example, for a mortgage would be regarded as a reasonable spread of results. You don't have to have 100 different ones. And so since that is an active market which is driven by people who understand what they're doing, I think that's a very clear indicator to the court of what an appropriate yield might be to expect on a reversionary interest.
If we turn back to expert bundle 1, I hope you've still got open at page 101. Paragraph 7.3, you say that the potential difficulty is this market is quite restricted. Have you got any evidence to suggest anything other than that market is restricted?
Well, I think you've just been making the point.
Yes, so that market is restricted. You agree with that?
It is a small market, but it is a market, and I think it's a better indicator than anything else we've got. It's a much better indicator than doing a synthetic calculation using a future growth of house prices of 3.1%, which nobody would regard as a sensible way of valuing the reversionary interest.
If you then read the rest of that paragraph, you set out a calculation which you carry out as a sense check.
You're referring to another paragraph which is about...
Paragraph 7.3, you say the following calculation, based on the UK population mortality and a low-risk investment approach, provides an order of magnitude assessment of value.
Okay, yes, the word sense check comes in another paragraph. No, I mean, I did a calculation just to show how the reversionary interest is calculated. In fact, it's the obverse of the life interest. The 3% was not telling me anything there. In fact, I gave the range of what I thought were more reasonable discount rates in paragraph 7.5, and that does encompass the range that Mr. Watson is talking about in his experience. So I think a realistic assumption for the court to set, if it needed to set an assumption, would be a yield of 5 or 6%.
Sorry, on what basis do you say a yield of 5 or 6%?
On the basis of being informed by the market value.
Right, so you just you start with the 6.6% of Mr. Watson, and you say 5 or 6. Why 5 or 6?
Why not? I mean, 6.6 is too accurate, or appears to be spuriously accurate given the uncertainties of the exercise. The results are not enormously sensitive to a change. I think it would be perfectly reasonable for the court to set a figure of 5 or 6% as a simulation of an approach to market value.
So, I think your first answer was why not? Is there actually any science between getting to 6 from 6.6, which you say you use as your starting point, to 5 or 6?
Well, I would say 6 is close to 6.6. I don't think you could possibly set it at 6.6. That appears to be too accurate. But if the court felt that was being too mean on the value of the reversion because of the limited nature of the market, then 5%. You can get it the other way. I think in Mr. Robinson's report, he tries to build up a case for looking at the discount rate for a reversion on a similar approach, if you like, sort of backwards approach to what the Ministry of Justice did in setting the discount rate. I didn't agree with some elements of his calculation, but I would, from that, I would deduce something like 4% as being a bottom line discount rate, about the lowest you could possibly justify. But I think 5 or 6% would be reasonable in this case.
In your calculation,
Hermione, I am worried about the time. I gave you a bit of indulgence, but you've already been another 10 minutes.
my lord, yes, just 2 more minutes, I hope.
Very well.
My lord, I just wanted to ask to finish this topic, if I may. Paragraph 7.3, you use a rate of 3% for a fund that will have no growth whatsoever.
Yes.
If an assumption is that it is a reasonable assumption that house prices will match retail price indices growth, and that RPIs are going to be positive in the future, then as you say at the end, the value of reversion would clearly be significantly higher if the allowance was made for possible future growth. So if you use 3% to value a fund with no growth, surely you would use a significantly lower number to value a fund, the reversion interest in the fund, which can expect some capital growth in line with inflation.
Well, I don't think I would, because I've read the report of Mr. Watson. I understand how the market is working, and the 6.6%, which is the implied yield in his report in the transactions, it allows for inflation, and so that's what people are expecting as the yield on such an investment, allowing for their expectations of what might happen to property prices in the future.
Mr. Dakin, can I finally just take you to your calculations?
Which ones?
The ones that you just handed up this morning?
Oh, yes.
In those calculations, you give values at different percentage rates, but you use the table 28 multipliers to calculate out those values.
I was trying to produce a table which was consistent with the 49,000 and a couple of other numbers which appear in Mr. Watson's report.
Because Mr. Watson's calculations make no allowance for mortality, do they?
They do make allowance for mortality, but that's taken account of in deciding what yield to set.
In terms of your assessment, we can see in paragraph 7.3 that when applying a 3% yield, you calculate it through using the table 2 multiplier, don't you?
Yes, and that's the way I would expect to do it, but it doesn't really make much difference, and I wanted, in producing that comparative table for different interest rates, simply to illustrate it on a basis which was consistent with Mr. Watson's report, so we didn't get into an argument as to whether it was calculated using table 28 figures or table 2 figures.
But it does make a reasonable difference in that your figure for a 3% yield is 255,145, whereas Mr. Watson's is nearly 10% lower at 235,000.
Well, I wouldn't regard that as a very big difference in the context. I mean, I think the correct way to do this is to allow for mortality, but Mr. Watson is allowing for mortality in a different way, and so these figures are based on the way he's approaching the allowance for mortality and looking at figures which would be consistent with the 6.6% yield approach which he's using, and probably also which would be easier for the courts to adopt in practice in calculating reversionary interest if the rate was set at 5% or 6% along the lines of Mr. Watson's approach.
Mr. Dakin, can you please help? You say that Mr. Watson used mortality in a different way. I just need you to explain what you mean.
Oh, well, he does. I mean, I think this is really a question for him, but he allows for mortality. He assumes a fairly old version of the Ogden tables, although curiously the Ogden 8 tables, which are coming out in a few days' time, will be very similar to those. But he allows for the underlying mortality in deciding what he thinks the yield is that the investor is trying to secure. So he's already taken account of the mortality in arriving at his 6.6% figure, and he then can use the 6.6% figure as a fixed compound interest sum for a fixed term, because mortality is already taken into account in the calculation.
Is that because those who enter into this market are allowing for mortality, and he's looking at the results of their judgments about mortality?
I think he is, yes. And I mean, he's trying to understand how the market works. And I think, again, I don't want to take words out of his mouth. One reason that he's using a fairly old mortality base is that he's trying to achieve consistency at looking at these types of instrument over time. So he doesn't want to keep changing his mortality basis, because yields he was getting. By using a constant underlying mortality basis, you can then see if yields are changing or not.
Anything else, Mr. Viney?
Lord, can I just take a moment to check with Mr. Ordnance to see if I've missed anything important? Sorry, thank you, my Lord. Mr. Dakin, thank you very much, my Lord. Those are all the questions I have.
Thank you very much, Mr. Viney. Do you have any questions in re-examination, Mr. Speaking?
Well, just two, I think, or two areas, if I may. Mr. Dakin, you were asked about reversionary interest by reference to your report at paragraph 7.3. Do you have that?
Yes.
As I understand it, you're setting out an illustrative calculation in that paragraph, and then you are making the mathematical point that the value that you calculate for the reversion would be significantly higher if one factored in possible future growth.
I just lost it. It's gone.
That's it.
Mine has. It's theirs.
Pick up my call.
See, let's try. Call Cara. Oh no, she got him.
Yeah, hi, Cara and Scott. The lady's just lost audio, and we're not sure how to sort of rectify it. Right. Yeah, we've got visual, but it just went. So, should I give Alarm a call? Might be better. Okay, no worries. That's fine. That's fine. I'll call you if I need you. Okay, thanks, Cara. Thank you. Bye. Bye. I'll give Alarm a call.
Yep.
She just reboot. Is that rebooting or? I'll give Alarm a call.
Let's try. Let's try this.
Apparently she said there has been problems with it this morning
Let's try here.
in others.
minute. Good morning. I lost a complete connection. I'm not sure about the live stream. Did other people lose connection?
No, I think it was just you. You haven't got the live stream on.
Live stream isn't on. It's saying it's recording.
It is, yeah, it's indicating that it's recording.
Yeah.
It's gone again.
Has it?
Yeah.
I think I might call him actually, the lady. Yeah, hi, it's Scott. We've lost audio on the lady's computer, and as well, we're not sure about the live stream as well, so I'd need you down here to have a look at that, please. What was that, mate? Okay, thank you. Cheers, bye, bye. Alarm's on the way.
I went back in once and then it cut out again.
There's major problems with Skype this morning.
Out there?
Across the board. I've given up being in the hearing because mine kept going.
Really?
I think what we'll do is we will just wait another minute because that should be enough.
Right.
We have you audio, we have you visual again. There's obviously a slightly unstable connection there.
I think that it's a wider problem. I've just been told by my clerk that there are problems elsewhere with Skype this morning, and she in fact has given up with this particular connection. Let's try again. I've alerted the administrative staff, so we'll see how we go.
Thank you very much indeed. Yes, perhaps you could just indicate what your last note is. We would.
It was Mr. Sweeting, and he had taken Mr. Daking to 7.3.
Yes, and the essential point being made there, have I got this right, is that you were being asked to expand on what you had said at the beginning of 7.4 about why this would be a relatively high-risk investment. Could you just say in a sentence why that is, and then that's probably enough for Mr. Sweeting's purpose?
Yes, my lord. I think the illustration 7.3 was purely a mathematical illustration of what happens if you apply a 3% discount rate and the capital you're trying to recoup is 900,000. I'm saying that in 7.4 that the market wouldn't use the low risk approach like that and would use a much higher rate of discount because this is a relatively high risk investment. I gave some illustrations in paragraph 7.5 as to how it varies by the discount rate you assume, and I think we are finding from Mr. Watson's report that the market would actually allow something like 6.6%, and that would incorporate an assumption of inflation of property prices.
Yes. Mr. Sweeting, what was your other question? On area. Was that enough on that area?
I think that's enough. I think the net result of that, Mr. Dakin, is that with the risk being higher, the market is prepared to pay less.
That's correct, yes.
If I could ask you please to turn to page 98 and paragraph 6.2.
Yes, I have it.
You were asked a number of questions about your principle 3 and also the suggestion that a cash flow analysis could be applied to damages, and you were also taken to your Appendix D in relation to those questions. I'm not going to ask you to go to Appendix D again. At 6.2, you refer to the argument that it would not be necessary for Mrs Swift to take out a loan until she was 80 years old or more. I think that is in effect a reference to the cash flow argument. Is that right?
Well, I think it got mixed up into two separate approaches that were used by the defendant's actuary. One was in relation to considering a cost of borrowing approach, but only assuming that the borrowing was needed late into life, in 35 years' time. And it also came into the equity release approach, where the whole of award was placed at the disposal of the claimant to use for capital as well as revenue purposes. So in both of those cases, there was an assumption being made that borrowing wouldn't take place till later, which is obvious.
I think there may be a misunderstanding here. Mr Sweeting was merely laying the grounds for a question.
Oh,
yes.
sorry.
6 point, if you just, don't mean this rude, if you just listen to the question, I think 6.2, he was simply saying that that 80-year thing was based on the cash flow assumption. That was your point, Mr Sweeting?
Yes, it was. Perhaps I should express it more clearly. I think the scenario which you were being asked about is that the claimant receives a lump sum of damages, or a lump sum element of 3.8 million, and is able on a cash flow basis to use that up during the course of her life, and then at a further point, around 80 years old, to release equity from the property in order to make up any shortfall.
Yes, well,
I think, is that correct, Mr. Davies?
When the court intervenes, so it often always causes more problems. So I'm not quite clear what your question was, Mr. I thought you were just laying a ground for a question you were about to reach, but maybe I misunderstood.
No, my lord, I am. I was trying to lay the ground more clearly. I obviously haven't.
What is the question? I think that's the
so the question is this. You go on in paragraph 66.2.
We've lost Mr. Dakin's image. Mr. Dakin, have we lost your audio? Well, the computer system obviously recognises that this part of the evidence is overrunning and is protesting. We'll have to do what we did with my lady and just wait for a moment. Normally it comes back. I hope Mr. Dakin knows how to rejoin. If we have a long break, I think what we'll do, Mr. Sweeting,
yes,
is, with apologies to Mr. Dakin, move on to another witness. You can then reflect whether the question you need to ask him is one you really need to ask him, and if it is, we'll interpose him shortly later in the day. But let's give him another minute or two. Yes. just while we're waiting, the next witness is Mr. Angel. Mr. Orland, are you going to take, sorry, Ms. Angel, you're going to take her, are you?
Yes, my lord.
She is ready to go.
Yes. I'm just checking the list of participants. Yes, she's on the call.
Well, I think, again, my lord, my lady can't, I'm afraid, pass me secret notes. But unless they disagree, I think we will take the course of which I suggested. Could someone get a message to Mr. Dakin saying that we can come back in at his leisure, and that if there is the need for any further questions, we will try and fit him in as soon as possible, perhaps after Miss Angel.
My lord, I am back in. I lost the connection.
Yes, oh, very well. I'm sorry, we were just about to do without you, but or at any rate put you off. Well, Mr. Sweeting, can you now ask the long delayed question?
Well, certainly, yes. So the 3.8 million assumed an investment in property, but not an investment in residential property. Is that correct?
Well, there's a slight nuance to that. The 3.8 million assumed a discount rate of minus 0.75%, which was a risk-free rate of return assessed by the Lord Chancellor in February 2017. Because that assumed no specific portfolio, just a risk-free rate of return, I looked to how the Lord Chancellor had made the calculation in June 2019 in order to get some understanding of what happens if you change the portfolio. And so I was using the figures which underlay the setting of the discount rate at minus 0.25%, and I attempted to show in a rather sort of simplistic way in my appendix that if you take out a very small proportion of investment in commercial property, which is high yielding, and replaced it by a large interest in a domestic property which is not yielding rental income, then it diminishes the rate of return quite a lot, and so that would have a big impact on the setting of the discount rate if you did it that way.
So the point is that a forced investment in residential property undermines the basis on which the discount rate itself was calculated.
Agreed, yes, exactly, my lord.
That was the point you were making when you under cross-examination. Was there some further point you wanted to get out of it, or did you just make sure we'd understood that, Mr. Sweeting?
Well, that was all, thank you. I was after that answer to that question, and that's all I have to ask. Thank you.
Thank you very much, Mr. Dakin. This will probably be, well, it probably may not have been your first experience being cross-examined online, but I'm glad it's been at least relatively technically unproblematic, at least until the last few minutes. Thank you very much. Well, we'll now move straight to Miss Angel.
Thank you, my lord. Miss Angel, are you there? Can you switch your...
Yes, I'm here, and hopefully you can hear and see me.
We can't see you yet. Yes, we can.
I need to pin you so that we don't lose you again. Yep.
Yeah.
Again, try and leave it to you, Mr. Orland, but I think we, one way or another, if you could either take the oath or affirm, as I say, you had the correct form of words.
Yes, I've got them here. I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you, Miss Angel. Yes, Mr. Orland.
Miss Angel, could you give the court your full name and professional qualifications?
My name is Kate Alison Angel, and my primary qualification is a Fellow of the Institute and Faculty of Actress.
Thank you. I think you've set out your curriculum vitae in more detail in your report. Perhaps I can ask you to produce your reports. You should have bundle 2, which is where all of your reports are contained.
And your main report is at tab 8.
Yeah.
Which I believe is signed by you on page 466, and that's your report from December 2019. Your next involvement was the joint discussion and joint statement, which we find at tab 14 with Mr. Dakin, signed in January of this year. And then your last involvement is a supplementary report you produced in the light of recent events, which we find at tab 21 at the back of this bundle, starting on page 615. Those are your two reports and one joint statement. Can you confirm, please, that the contents of those reports accurately reflect your opinion in this case?
Yeah, I also responded to some questions as well, which I think at tab...
You did.
Sorry.
Yes.
Just to be complete now.
It's tab 10, starting at page 487. Thank you. That was also January. With that addition, you contend that your opinions you've expressed in those 4 documents accurately represent your opinions in this case?
Yes.
My Lord, I'd like to ask one further item of clarification arising out of the latest report, please, if I may. Ms Angel, could you turn to tab 21 and page 626? This is section 2 of your report, and you essentially revisit your calculations conducted in your main report in the light of the supplementary forecasting by Mr. Wilson. And you produce an updated version of table 7.2, which we see there. And then at the foot of, beneath 7.2 at paragraph 2.5, you say in the last 2 sentences, the additional compensation payment due to insufficient equity and property, and that is the penultimate column moving left to right on the table above, isn't it?
Yes.
Those figures have increased to a more significant extent given the additional impact of the reduction in house price inflation that comes from Mr. Wilson's evidence. This results in an increase in the compensation payment required to fund borrowing requirements, which are more likely to exceed the value of the property at some point in the future. Now, in your original report, when you've done this exercise, you produced, and I'll take you to it, please, you produced Appendix E2, I think it was, which you referred to at paragraph, if you turn back to 459, 460, please, at the beginning of this bundle. We see on 459 the original table 7.2, and then over the page in 715 we refer to the cash flows being set out in Appendix E, and we can see from Appendix E on page 482 under the accumulation of interest cash flows, that's the not the interest only option, but the accumulation of interest cash flows. You set out here effectively, as I understand it, that if we look at the additional costs payable column, penultimate column, does that tell us when the money runs out and when she has additional loss?
It's effectively when all the equity in the property is used up, so there's an additional cost, yes.
And we see from this table that that would happen at about between 95 and 96 years old.
Yeah.
After her, according to the judgment, her life expectation was till age 89. The only question I had, because you didn't reproduce table E2 in the supplementary question, is how do the revised calculations affect the date when the equity runs out?
So in terms of section 2 of my supplementary report and the assumptions in that section, the claimant would run out of funds, or the equity would be used up in the property, when she would be 93.58. And
that's in section 2 of your report.
Yeah, in 2 of my supplementary reports, yes.
That's the section where you are assuming that house price inflation matches price inflation.
Yes, at 2.96.
And then in section 3 of the report, which is where you assume house price inflation is less than price inflation, what age do we come to there?
And for section 3, so it would be 92.58. So that would be the age that I'd estimate the claimant would run out of equity in the property under those assumptions.
Thank you very much. If you wait, Mr. Sweeting will have some questions.
Yes, Mr. Sweeting.
Yes, good afternoon, Miss Angel. Could I ask you, please, to look at your original report, please, which starts at page 440.
Yes.
And at 2.2, you set out alternative approaches that you had been asked to calculate. And that's essentially what you do in your report, isn't it? To perform calculations based on assumptions that you've been given.
Yes.
Yep. And the 3 are reversionary interest, cost of borrowing, and the equity release approach. Perhaps we can just start with the cost of borrowing and deal with this quite quickly, because if we look at your summary in relation to that, which starts at page 441 and goes over to page 442, you say at paragraph 2.14 that this approach implicitly assumes that it would be possible for a mortgage to be obtained for the life of the claimant in line with the borrowing costs assumed. And that is the central assumption that has to be made in relation to this approach.
Yeah, and I guess my calculations implicitly assume that I make no opinion as to either whether that is a reasonable assumption or whether it, you need it in reality, or whether it's actually okay to do a theoretical calculation in this case.
And as well as that, you assumed, I think, that the claimant would put some part of her damages into the mix.
The cost of borrowing, I don't explicitly make any assumption about that. I just assume that the claimant, will borrow a certain amount. And those amounts were given to me as part of my instructions.
Well, if you turn on to page 452, I think your instructions, in fact, dealt with 2 alternatives, didn't they? One being that 900,000 is borrowed, and secondly that 770 is borrowed. And that's
Sorry, which page do we see this on, Mr. Sweeting?
It's 452, my lord, paragraph 6.1 in the report.
Sorry, I'm getting very sensitive about this. I now notice I don't have Lady Justice Nicola Davies on screen, but it may be that I'm not showing her.
No, I'm here and I can hear everything and I can see myself on screen if no one else can see me.
I need to pin you. I don't know how I managed to avoid it. Okay, thank you. Sorry, you were giving me a reference, Mr. Sweeting, for the instructions.
It's paragraph 6.1 in the report and page 452 in the bundle, my lord.
Yes, thank you very much. And the question was?
That in fact you've made 2 assumptions, or there are 2 alternatives proposed under cost of borrowing. One is borrowing of 900,000 and the other is 770,000 assuming that general damages, pain, suffering, loss of amenity is used to fund the property. Is that right?
Yeah, but that was effectively in accordance with my instructions, yes.
Yes. Yeah. If we go back, please, to page 442, you then move on in the summary to equity release. And you start at paragraph 216 by saying that you've been asked to assume that the claimant uses part of their compensation award to purchase a property. So that is to fund the 900,000.
Yes.
Right. And the source of those funds would be the damages which have been awarded as a lump sum, 3.8 million.
Yeah, effectively, yeah, under the equity release approach, I treat sort of the award that's made to the claimant in totality, if you like. So yeah, effectively funding the property from the lump sum award.
Yes. And you haven't made any adjustment to the lump sum award of 3.8 million to reflect the fact that that lump sum was arrived at other than on the basis of an investment, in this case about 25% of that figure, in a residential property in which the claimant is to live.
Well, I have adjusted for it in the fact that when I'm doing the cash flow calculations and I'm assuming a future investment return in line with the discount rate that was used in this case, that actually the funds that are giving rise to that investment return is reduced because a proportion has gone into the property. So I've effectively, the equity release, the easiest way to think about it is sort of a pot of money. The claimant receives this pot of money, a proportion is then used to fund the property, and that gives no rise to any investment income, although I obviously allow for the increase in value of the property, but it gives no investment income. And the remainder of the claimant's compensation award does give rise to investment income in line with the assumptions underlying the discount rate used.
But you would have to adjust, wouldn't you, the discount rate if you were going to reflect a lump sum which required the claimant to invest 25% of her damages or thereabouts in her own property.
No, because I'm not assuming she's getting any return from that 25%. I'm allowing for the fact that it will increase in value and therefore she can borrow against it, but I'm not allowing for any return. I'm effectively assuming a smaller return, which is partly why, you know, I'm predicting she's going to run out of money before her expectation of life. So I guess I fundamentally disagree with Mr. Dakin in that you don't need to adjust the discount rate, because I'm not assuming that that 900,000 that's going into the property is being invested. I'm assuming a smaller proportion is being invested. The 900,000 goes into the property, and the only benefit of that, if you like, is the fact that the claimant can then borrow against it in future years when she is predicted to run out of money.
Right, well, can I move on then? The point that you've just mentioned is, to put it bluntly, central, isn't it, to your analysis here, which is that at some point the claimant will run out of money.
Yeah, and therefore the premise is that she can, it's a theoretical calculation that I've done that she can then borrow. She's run out of cash, if you like, but she's got a property that in current terms is worth 900,000, and in the future, using the assumption I'm giving, will be worth more, and therefore she can borrow against that property to fund her expenses later in life, and therefore, there's a fairer compensation because it's effectively reducing that asset that the claimant is sitting on that either she could sell or draw down against, or would then go to her dependents on her death.
So the lump sum which the court has calculated on a head-by-head basis relates to, for example, the cost of therapies, care, loss of earnings, and so on. You are contemplating that those needs cannot be met to the extent to which the claimant has had to use that money to fund the purchase of the property, and so at some future date will have to release equity in order to meet those ongoing expenses.
Yeah, I'm not, splitting the total compensation amount into different heads of damage. I'm treating it as a single amount, and therefore looking at the future cash flows, both in terms of funding the initial property and all the other costs and losses that have been agreed in this case.
And on the assumption that that sum of money, the lump sum, is funding ongoing needs and the need for ongoing income by the claimant, it is crucial, isn't it, to have confidence about whether or not you can identify the point at which the claimant will run out of money, and whether or not at that point the claimant will be able to bridge the deficit by equity release.
I mean, my view is that there's lots of uncertainties in any compensation amount. So, the courts are quite familiar with using life expectation. The reality is that no one knows when they're going to die, and there's a lot of uncertainty around that. There's also a lot of uncertainty around future investment returns and future inflation. The reality is that, claimants receive a lump sum that could be more than sufficient or not sufficient, depending on how the future pans out, including how long they live. As with anyone, people can die tomorrow, or you can live till you're over 100, and no one knows. So this is additional uncertainties, but it's whether they're acceptable in order to get a fair compensation amount in respect of accommodation as well.
And in relation to equity release, we find at page 443, your table 2.3, a summary of your findings. And at that stage, for the purpose of producing that table, the age at which you were positing that the claimant is expected to require additional funds, in other words, to run out of money, was a little bit short of 78 or 79 for some scenarios, and a little over 79 for others. Is that right?
Yes.
So the court would be looking forward to the claimant's old age in order to be satisfied that the claimant would be able to obtain funds through equity release.
Yeah, in the equity release, as you say, that's the age where I would expect the claimant to run out of funds, given that she's sort of funded the property out of her compensation amount, and therefore it's at that age that she would need to release funds, assuming she's still alive at that stage, to fund her ongoing cost up to her expectation of life.
Hardly needs to be said, does it, that is many years into the future in this case?
It doesn't need to be said, Mr. Sweetie.
Well, I've asked the question one shouldn't ask. It hardly needs to be said, does it? But that is many years into the future, and therefore there must be real uncertainty about what assumptions can legitimately be made.
Yeah, I mean, I agree there is uncertainty, but as I said before, there's uncertainty about how long the claimant will live, what investment returns she's going to get on her compensation, what inflation is going to be. So this is an uncertainty, but there's also a lot which the court are much more familiar with in assessing, lump sum compensation amounts.
So could you turn on, please, to page 444 and your paragraph 2.24? You are commenting on your own methodology here, I think.
Yeah.
And you say that it does require a significant number of assumptions which are uncertain and rely on expert judgment. These include house price inflation and future cost of borrowing under an equity release type arrangement. It is, in fact, isn't it, essential for this analysis that you include house price inflation?
Yes. Yeah, there needs to be an assumption about that, yes.
Yes, and indeed...
So sorry, as an about that or an assumption of that? An assumption there was no house price inflation would be an assumption about house price inflation, but it wouldn't be an assumption of house price inflation. I wasn't quite sure what you were agreeing.
I was saying that there needs to be an assumption of house price inflation. That could be, as you quite rightly predict, an assumption of zero inflation, or it could be in line with RPI, or it could be any other number. They're all alternative assumptions.
Because you're relying on, aren't you, ultimately on equity in the property in order to meet the claimant's needs when she runs out of money.
Yeah.
And then at 2.25 you say, the approach also implicitly assumes that such an equity release type arrangement on borrowing rates consistent with those assumed will be available when the claimant's funds are exhausted and the claimant needs to borrow funds to cover her expenses. So there also needs to be an assumption that such a product will exist when the claimant reaches old age and runs out of funds.
I would slightly potentially disagree with that. I think, to me, it's up to the court to decide whether you need to be comfortable that there is such a product. When the Ogden rate is set, for example, on a index-linked gilt rate, they're not, the court is not necessarily expecting a claimant to invest in index-linked gilts and hold them to redemption in order to benefit from that link to RPI. So, and I'm not expressing a specific opinion on this. I think it's up to the court to decide whether the court needs to be comfortable that there will be such a product, or whether actually an assumption of such a product is sufficient to get a reasonable compensation amount that then the claimant can do with as they wish.
Well, presumably there needs to be some method, doesn't there, of releasing equity from the property, unless you're assuming the claimant is actually going to make completely different investments with her money, which will somehow otherwise bridge the gap.
No, my comment is, I don't think there needs to necessarily be those products in the same way that what is the claimant going to do if she lives beyond the life expectation? Now, in theory, she will run out of money at 89, I think, is her expectation of life. And nothing is done about the risk that she may live till she's 100 or over 100. And in the same way, we could sort of implicitly assume that there's such a product and use that to get a fair number for both both parties in this case in terms of the accommodation costs, but not necessarily say that there has to be such a product in this many years' time.
If we look at the assumptions then that you're referring to, the significant number of assumptions, we can see those, I think, at page 448. Starting, I think, at your paragraph 4.3. And you introduce those assumptions by saying, in order to produce these calculations, several assumptions and approximations are required, which are uncertain and rely on expert judgment. The key assumptions that I've relied on, which are common to all the calculations, are detailed below. And they are, in effect, aren't they, calculations based upon Mr. Wilson's evidence. That's where the assumptions come from.
Yes, that's correct.
So, for example, I asked you about the assumption that there would be house price inflation, and there is such an assumption, and that is an assumption of house price inflation at 3.2% per annum.
Yes.
And you're not in a position to comment on whether or not that's a valid assumption, you've just used it in your calculations.
Yeah, I defer to Mr. Wilson on that.
And that assumption holds good over the entire period during which you're doing the calculation into the claimant's old age.
Yeah, that's correct.
Right. And the same applies, doesn't it, to general price inflation, where the assumption is made that it's going to be 3.1% per annum.
Yeah.
Right. The comment you make about economic assumptions is set out at paragraph 4.6, where you say they can be subject to significant variability in the short to medium term and become increasingly uncertain as we look further into the future. So you are adding a caveat, aren't you, that the longer the period over which you are projecting those assumptions as a part of your calculation, to use your own words, they become increasingly uncertain.
Yeah, and again, I think, Mr. Wilson is an expert in this area, and it's more appropriate for him to comment on how uncertain they get. But I think, as you say, I would say that they do become increasingly uncertain. But, it's the same with the discount rate that is used. But that is also uncertain in terms of future investment returns and inflation.
Well, let's turn to a practical application of these assumptions to one of the issues in this appeal, which is valuing a reversionary interest. And if we turn on to page 450, we see at section 5 where you start on those calculations. Paragraph 5.2 sets out again the assumptions, the ones we've just looked at based on Mr. Wilson's figures, and also the nominal discount rate of 2.32 and so on per annum, and then identifies that you were using the mortality tables in the 7th edition of the Ogden tables, the most recent edition.
Yeah.
And your result, as a valuation of the reversionary interest in this case, we find at paragraph 5.5, where you value the reversionary interest today at 1.337366, 1.3 million. So more than the additional capital cost of purchase.
Yeah, which is driven by the fact that this case was settled on a negative real discount rate of minus 0.75. So wherever that discount rate is negative, the value of the reversionary interest will be greater than the current property value.
But that cannot be, can it, any calculation of what someone who wished to purchase a reversionary interest would be likely to pay?
I think it's driven by the fact that we've got a negative discount rate, which therefore is saying that inflation is higher than investment returns. And therefore, if you're projecting forward the house price with inflation and then discounting it back, you're going to come up with a higher value.
Yes, well that may suggest that it's an unrealistic way of arriving at a reversionary interest value.
Yes, I mean, or it's an inappropriate way to come up with a discount rate that gives a negative value. Depends which way you look at it.
Because if you wanted to purchase a reversionary interest in a house worth 900,000, you wouldn't pay over 1.3 million, because you could simply purchase the house itself, couldn't you, for that?
Yes.
And you would have spare change if your budget was 1.3 million to invest somewhere else. That's right, isn't it?
Yeah. Yes. But as I said, this is all driven by having a negative discount rate.
Yes. And you make the point over the page 451 at paragraph 5.9. The assumptions used in this calculation are a key area of uncertainty. So not only do they produce an unrealistic valuation in terms of the market value for any reversionary interest, what someone would actually be prepared to pay, or what someone could actually sell at, they are also subject to what you describe as key areas of uncertainty.
But I mean, I would say that may be the case for any. What I've set out, I guess, in table 5.2 is the value of reversionary annuities assuming different assumptions. and I set out them on various different assumptions without opining on those assumptions, but to give the court an idea of how the reversionary interest changes as the real discount rate is increased.
Yes, you refer to those additional lines of information at paragraph 5.7, and you say these alternative discount rates have been selected purely to illustrate the impact of changing this assumption. So there's no particular reason, is there, for choosing discount rates that go up to 1.75% and stopping there?
So no, the minus 0.75 is often the first one in the scenario one is obviously based on the real discount rate in this case. I've then increased it to show the impact of that. The 1.75 in scenario 6 I was specifically asked to increase, but yeah, you shouldn't draw any inferences by what I have or haven't included in that table other than the first and the sixth scenario.
And what actually drives the conclusions you're reaching as to the value of the reversionary interest is the assumption that's being made about house price inflation.
Well, the critical assumption is, well, it's two critical assumptions. It's the real discount rate, I would say, and the difference between house price inflation and RPI or retail price inflation. And those are the critical assumptions.
Sorry, one moment.
No.
Thank you.
And simply changing either of those two parameters alters the arithmetical output of the equation you're using, doesn't it?
In terms of, in the two parameters, the real discount rate and the differential between house and retail price inflation?
Yeah.
Yes, yes.
And if you weren't building in house price inflation, you would get very different results in terms of the value of the reversionary interest, or indeed for your earlier calculations in relation to the potential to release equity.
In terms of by assuming zero house price inflation?
Yes.
Yes, you would get very different. If you assume lower house price inflation, whether that's lower as in all the way to zero or some number in between, it will affect the reversionary interest.
And so this calculation of reversionary interest does not tell us, does it, what the claimant would have to pay if the claimant wanted to buy the reversionary interest, or what the reversionary interest could be sold at what price in any existing market for reversionary interest.
No.
And you weren't actually asked to carry out that exercise because I suspect it would be beyond your expertise.
Yeah. Yeah, I guess there's other experts, I'm sure, will comment on that.
Thank you very much, Mrs. Angel. Well, those are all my questions.
Thank you very much, Mr. Sweeting. Mr. Orland.
There's no re-examination by me, my lord.
Thank you, Miss Angel.
My lord, before Miss Angel goes, may I just...
Yes, I'm so sorry.
No, not at all. Miss Angel, going back to the issues of borrowing and equity release and when monies would run out for this particular claimant, and let's just look at this particular claimant. It would be when she is at an older and somewhat more vulnerable stage in her life.
Yes, it would be when she's older, yeah. I think the numbers are around, in terms of running out of funds, would be around 78, 79, depending on the precise assumptions, but that sort of order of magnitude.
Yes, thank you.
Very well. Thank you very much, Ms. Angel. I'm glad you didn't have any technical dropouts, but perhaps that was because you were on the screen for a shorter period. Yes, so the next witness is Dr. Llewellyn. I I have a slightly sinister yellow bar on my screen saying that John Llewellyn isn't using Skype for business, but perhaps that doesn't mean what it appears to mean. Mr. Sweeting, you're about to call him?
Yes, well, I'm about to call him. I think it just means that he's using an iPad and it's probably not recognised as being the same software, my lord.
Good.
We did have a check earlier. So, Dr. Llewellyn, could you turn on your video camera, please?
I believe it is, but if it's not, I apologise.
It probably is on, but just it hasn't yet registered you. Now you've spoken, I hope you will pop up.
Yeah.
I haven't seen you yet, but if others have, I'm sure I will soon. Yes. Dr. Llewellyn, you've seen, I don't know whether you've been watching throughout, but
yes,
I assume you're in the same position as the others and in a position to take an oath or affirm as you prefer.
Yes.
I ask you therefore to do so.
I, Graham Glynis John Llewellyn, do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Yes, Mr. Speaker.
Yes, Dr. Llewellyn, you've prepared a report for the purpose of this appeal in the experts bundle at page 73.
Yes.
You also prepared a supplementary report, that's at tab 22 in the second expert bundle.
Yes.
And was that to express some views from an economic perspective on the impact of the present pandemic?
Yes, it was.
And in addition, there is a joint statement made between you and Mr. Wilson, which is at tab 13. And you weren't I don't think anyone asked you to answer any questions, Dr. Llewellyn. So that is the total, I think, of the expression of your expert opinion in relation to this appeal. Well, I've no further questions for you in chief. There'll be some questions in cross-examination, no doubt.
Yes, Mr. Orland, I'm afraid I didn't make a note of whether it was you or Mr. Viney who would be doing
It's me with Dr. Llewellyn. Thank you, Earl. Good afternoon, Dr. Llewellyn.
Good afternoon.
I'd like to start, if I may, with one or two general propositions which I believe we can probably agree. The first is, do you agree that the current levels of return on all investments and the current costs of borrowing are both substantially lower than they were 20 years ago when the House of Lords set the discount rate in Wells and Wells?
Yes, they are. In fact, interest rates are lower than they've been for 345 years.
Indeed. And the second proposition I'd like to ask you is this. Whereas here a claimant has bought the home without borrowing, do you agree that assessing the loss by reference to what it might have cost her to rent that property is not comparing like with like?
That's a complicated question. I want to make sure that I understand it. Would you mind repeating it?
Where a claimant has bought a home without borrowing,
yes,
do you agree that assessing the loss by reference to what it might have cost that claimant to rent that property for life is not comparing like with like?
Certainly, because when a person owns a house, they have capital loss or capital gain, as the case may be. When they rent, they pay a flow of income, and the two don't correlate always through time.
And as I understand it, that's precisely why economists devise the user cost of housing, so so that they could evaluate the cost of owning as opposed to renting.
Yes, it's an analytic device.
Could I ask you to look at paragraph 16, please, of the joint statement, which you'll find at tab 13 in expert bundle 2, please.
Yes.
And paragraph 16, Dr. Llewellyn, begins on 508 and runs over the page.
Yes.
It's right, isn't it, that historically, on average, the cost of housing has been negative, both for a borrower, someone who needs a mortgage, and for a saver, somebody who buys without.
Sorry, could you just, I want to note down the question carefully, could you just do it again, Mr. Ordland?
Certainly, my lord. I'm just asking, have you had, Dr. Llewellyn, have you managed, did I give you time to reread this paragraph?
Yes, you did, thank you.
Thank you. The question is, my lord, is it right that historically the average cost of housing has been negative both for borrowers and for savers who don't need to borrow?
I don't want to quibble, but what Mr. Wilson and I actually wrote was that historical statistics show, which is not quite the same thing as historically, because the answer to your question does depend on the period. Now, for the post-World War II period, that is what the figures show, yes. But I wouldn't go as far as to say that historically that's true, but there have been occasions when the reverse has been so.
But fair enough. So if I qualified it by saying in recent history,
yes,
those averages have been negative both for savers and borrowers.
Yes.
And I think you agree here in this paragraph that the house prices have increased by, on average, it's at the top of the next page, 1.9% per annum above RPI over the past 45 years.
Yes, I mean, that's just data, and of course I agree, yes.
Of course, and you go on to say here, even more if averaged over the past 50 years. We don't turn it up, but I believe that's a reference to your own evidence in your report, that over 50 years, it's 3.5%.
Yes, sure.
So, sorry, I mean, so, Mr. Ordland, which paragraph was that a comment on?
This, my lord, is the same paragraph, but it's the top of 509.
Yeah.
And the reference for your lordship's note, Dr. Llewellyn has kindly confirmed that the 50-year statistic is 3.5%.
Yes, that's
and the reference for your note, my lord, is page 79 for that statistic.
Thank you.
So, Dr. Llewellyn, the next proposition I'd like to ask you is this. If that recent historical trend continues over the long term looking forwards, then a claimant achieves a better return by investing damages in property than by investing in a low-risk portfolio.
Yes, with the word if doing all the work, of course.
We're going to come on to the reliability of forecasting in a moment, because I know that's a big area of dispute, but I accept the point that you make. But with that caveat, you agree?
Yes.
And there's an additional benefit to a claimant owner, isn't there, in tax terms, because investing in one's home gives one capital gains tax advantages.
That's my understanding, that that's the law at present, yes.
In terms of the user cost of housing, we look at, I think it's page 510, paragraph 31 of the joint statement. You agree that the method is a valid approach to assessing the loss in terms of ownership, and agree with the methodology adopted by Mr. Wilson.
We were very careful in our choice of words when we agreed them, and the actual words that we agreed were that it's a valid analytic approach. And it is a valid analytic approach.
Mr. Ordland, you were getting very fed up with me. Which paragraph was that a reference to?
My lord, not at all. That's paragraph 31 of the joint statement, page 510.
Yeah, got it, thank you.
Now, and I want to move on to forecasting now. So it's not that you dispute the analytic approach that Mr. Wilson adopts by reference to the user cost of housing, that you don't dispute that as an exercise. You question whether it's reliable in the long term.
I question whether it's applicable in the long term, yes. It's an analytic device, so it helps you decompose events when they've happened.
And can I ask you this? If you were asked to forecast user cost of housing over 40 to 50 years or 30 to 40 years, as Mr. Wilson has done, what would your forecast be?
Do you know, right now, and looking at the future as we see it dimly, I would not feel comfortable saying that house prices were, and hence the user cost of capital, more likely to rise or to fall over the next 20 or 30 years.
I'm sorry, Dr. Llewellyn, could you please repeat that and speak as loudly as you can?
I'm sorry. The question, as I understand it, I was asked was, if I were asked to make a forecast of the user cost of capital, which really means a forecast of house prices relative to the cost of running a house, what would that forecast be? And what I'm saying is I can as readily now imagine that they would fall as that they would rise. And it's therefore a forecast which I would not feel comfortable making.
Do you agree, whilst you wouldn't personally feel comfortable making it, do you agree that Mr. Wilson's forecasting, or the Oxford Economics forecasting, falls within a reasonable range of opinion?
Oh yes, and of course the irony of that is the wider the uncertainty, the more likely any one forecast is to fall within a reasonable range of opinion.
So can we turn, please, to the question of reliability of forecasting generally, and just explore
Just one moment, Mr. Woodland. Just one moment.
Could I ask a supplementary to that, Dr. Llewellyn? If we assume that forecasts are reasonable because they fall into a wider range, what does that tell us about the reliability of the forecast?
Yes, exactly. The counterpart to my statement is that the reliability of any one forecast is thereby so much the less. The Bank of England pioneered this to some extent with its famous fan charts, which showed how the reliability, or how the range of forecasts increases as you go out through time, and therefore the weight that you can place on any one of them within that fan is thereby diminishes over time.
So that's called the Bank of England what forecast?
It's their fan chart. It's a,
that fan chart. Oh, yes. Yes,
chart.
no, I see the image. Yes.
Yes.
You deal with forecasting, Dr. Llewellyn, on the same page at paragraph 34, 35, 36. I'd just like to refresh your memory from what's said there. And what you're effectively saying is that for you, in your opinion, it's not possible because you're not able to do it with a sufficient degree of certainty. You go on I think, to describe that as a high degree of certainty.
Mm-hmm.
Is that right?
Yes. The question
When you say a high degree of certainty, what sort of level of certainty in percentage or other terms are you looking for?
When one refers to the degree of certainty, that always has to be assessed in relation to the purpose to which the forecast is going to be put. This is something that I learned when I was in charge of forecasting at the OECD, and I wrote a chapter in a book about it. Because one of the criticisms that one always heard was, your forecasts are not accurate enough to make policy by. And then one realizes that, in fact, that's an inverted statement. The forecasts are as accurate as they are. And therefore you have to make policy taking into account their degree of reliability or unreliability. So that's my point to you, which is that these ones are not particularly reliable for the purpose of forecasting house prices 20, 30, 40 years out.
You mention in your report, if we can just turn to that, it's this is the first bundle, please, tab 3, page 78.
Paragraph
23, please.
Yes.
You make the point there at 23 subparagraph 2.1 that the Office for Budget Responsibility projects gilt yields for 5 years, only 5 years ahead. And you make that point in the context we see from the head of that paragraph of suggesting it's not possible to forecast interest rates for more than a few years ahead. Is that correct?
Mm-hmm.
We needn't turn it up, but we can see from your distinguished career that you are now on the advisory board for the OBR. Is that correct?
That is correct, yes.
And you'll be familiar with the OBR's Fiscal Sustainability Report of 2018.
Indeed.
You agree that in that report, the OBR bases its assessment of fiscal sustainability on assumptions about, for example, GDP, inflation, earnings, interest rates, over an even longer period than the period we're concerned with in this case.
Yes, I am aware, of course I am. But I would make the important distinction, in fact, I would say the vital distinction, between a forecast, which is something you expect to happen, and a projection, which is something that you do on the basis of stated assumptions and then use for some particular purpose. In fact, I myself started that process with a few people around the world at the OECD, and the difference between a projection and a forecast is fundamental.
And you agreed with my proposition. Just to be clear, the OBR are forecasting for that purpose. They were forecasting as far ahead on those items as 2067.
Well, there again, these are not, strictly speaking, technically forecasts, they're projections. And the reason that you do them, the reasons that we started them at the OECD, the reasons that the Treasury does them, the reasons that the OBR does them, is to examine the implications of a set of assumptions. In other words, for example, if the government continues with its tax rates as they are at present, if the population ages in the way that it is aging at present, and so on and so forth, what are the implications of that? That's not to be confused with a forecast. In fact, very often projections are made in order to induce a change in policy to ensure that they do not come about. Interestingly.
When you were head of international forecasting at the OECD, I believe.
Yes, I was.
And over what periods of time would you be forecasting for the purposes of the OECD involvement?
1 to 2 years. We did projections 30 years ahead, but we did forecasts 1 to 2 years ahead, because after a very careful inspection of the data and forecasting accuracy, we came to the conclusion that in terms of a pure forecast, in other words, saying what can you reasonably say will happen. 2 years ahead was about as far ahead as we thought we could look.
If one looks at the OECD website, they're forecasting to 260, but they call it a forecast in terms of GDP, not a projection.
Yes, they do. But I think it's widely understood in the profession that that's a projection, not a forecast.
Yeah. Well, it's called a forecast. You've called it a forecast. All you're trying to do as an economist is do the best you can to inform what is more likely to happen in the future than not, aren't you?
Yes, absolutely so. And that's why in the case of house prices, I said that in all honesty, in response to your first question, I could imagine them falling being as likely as rising over the period ahead.
Mr. Dorland, I don't know whether that's a natural break. If you don't think you're going to be very much longer, we might be prepared to sit a few minutes, but if you do think you're a bit more to go, I think we'll have to take a break now.
I will not be much, I won't be more than 5 to 10 minutes maximum.
We have been sitting quite a long time, and there will be, I don't know, my lord, my lady, have a view about this?
Don't mind.
I should have thought myself it was better to stop now because I suspect there may be question from the bench and re-examination.
I agree with that. Very well, we will reassemble at 2 o'clock. As before, I at least will not actually leave the meeting. I will merely become inaudible and invisible. So please remember that unless you mute yourselves, we may still hear you. Thank you.
Thank you, my lord.